Hello, this is Matt on the Moon Lambeau channel. And folks, I couldn't stay silent on this one. I had to respond to this on Twitter. I've been covering perspective from former SEC attorney Mark Fagel, who I do believe is operating in good faith, but he's got his perspectives, and he clearly wants to win the arguments that he takes on when it comes to Twitter. Okay? And I can understand and appreciate wanting to be right here. But he was framing something in a way that I knew just flat out wasn't true. And so he's talking about Judge Torres in the SEC v. Ripple case insulting XRP holders in an offensive verbal attack, saying that we're unsophisticated. She literally didn't say that. And so I'll show you the breakdown, but this is the first time I ever, and I've been observing. I'm mostly, like, when it comes to Twitter, a lot of times I'm just reading stuff kind of like fly on the wall, hanging out in the background. And I've read a ton of stuff from attorney Fagel, and even though I don't find his perspectives to typically be very persuasive in this case, I couldn't help myself. I had to respond because I knew flatly what he was stating was blatantly just untrue, and I had to respond. And I think that it's not that he's being intellectually dishonest outright, not like a John Reed Stark type who was also a former SEC attorney. I think that what he's doing is he's putting tremendous spin. He's trying to put spin on it to be persuasive, but he went too far into a realm where what he stated wasn't true. I called it out, and then he ghosted on me. He did respond to me, but then he ghosted on me after I pushed the matter. So I'm just going to highlight that because I think it deserves to be highlighted. And then another thing that was being discussed here is brought about by what is actually the largest cryptocurrency YouTube channel on the entire planet. The guy that runs that, he's talking about the SEC v. Ripple case not being so airtight, and that this idea that there's not sufficient clarity for XRP, and what if an appeal happens and this and that. And I frequently disagree with this guy, whose name happens to be Guy. And I'll just say, and it's nothing personal against him at all, but I remember years and years and years ago, before his channel was anywhere near being the largest cryptocurrency channel on the planet, he still got some little bit of traction, and I was aware of him. He was on my radar, and he'd make these videos about Ripple and XRP, and it was just nonsense stuff. And so already here I was like, okay, this guy's putting out nonsense. Either he's lying or he doesn't know what he's talking about. I can't rely upon the analysis of this individual. And so if you're a person who isn't doing your own research at all, you might find his persuasive language to be reasonable, compelling, accurate. But for me, having actually done research about, even in the early days, about XRP specifically, hearing the outright falsities he was putting out, I was like, okay, well, this is a source I can't trust. But still, the channel grew. And now he's saying more stuff that is just obviously nonsense, so I got to address that in this video as well. And again, it's not a personal attack, but it's just, if you're going to put out to a ton of people ideas that are incorrect, just expect to be challenged. And the same thing here. Whatever I say, I expect that I'm going to be challenged. And rightfully so. If you think that I'm wrong, if anybody thinks I'm wrong, you're not being, unless you're intentionally going out of your way to be completely rude. The act of contesting my ideas is not an attack in and of itself. In fact, I think debate's fun. Go ahead. Anybody can challenge me. And so that's all I'm doing here. And so nothing personal against Attorney Fagel either, but I still have to call this out. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Very minor amount of table setting. I made a video about this just the other day. There's this tweet from Attorney Filan, which reads as follows. In the SEC v. Terraform Labs / Doquan case, the SEC has filed a pleading discussing Judge Torres' decision in SEC v. Ripple, in which it states that, quote, SEC staff is considering the various available avenues for further review and intends to recommend that the SEC seek such review, end quote. And then they said, quote, SEC says XRP ruling was wrong, signals it will appeal, end quote. So that's the title there. And it is true that the SEC is indicating that they're going to appeal, but they haven't committed to it. And I cover that in detail in a separate video, so I'm not going to do that here. I just want to make sure everybody knows that so that everything makes sense and there's proper context. Now, in response to that, Attorney Hogan also said, and this is what kicked things off here, he said, heading into a settlement conference, an appeal is really the only ammunition the SEC has against Ripple. Of course, it says it will appeal. I don't think you can read too much into that statement one way or another. This is where former SEC attorney Mark Fagel jumps in and he says, presumably they wouldn't represent to the court that the staff planned to recommend an appeal if they didn't do so. But I believe the commission needs to vote to authorize it. And Attorney Hogan responded and wrote, the SEC engages in puffery and obfuscation like any other litigant. We've seen that illustrated in the Ripple litigation. So I find that to be persuasive, and having followed the SEC v. Ripple case for over 2.5 years, I firmly agree with that. Now, Attorney Fagel, coming from the SEC, he's disagreeing, and I'll just take his word that he firmly believes this, but I don't find his perspective persuasive. He wrote, no lawyer who worked for me would sign a brief representing to the court that they planned to recommend an appeal if it was not true. Sorry, of course, having navigated that bureaucracy, that recommendation doesn't mean the SEC will in fact appeal. Many hurdles to climb first. So I don't find that persuasive. I think that the SEC is not operating in good faith. I think they've shown they'll make whatever arguments they have to just have the winning argument. Frankly, they'll argue whatever they have to win. You know, facts and what is right be damned. They just want to win. Now, an XRP community member named XR Plumber wrote to Attorney Fagel and said, could a vote not be worded in a way as to authorize an appeal if certain settlement conditions sought by the SEC are not met? And Attorney Fagel did respond and said, I don't see that. Ripple got a nice clean win on the programmatic sales, albeit in an insulting way for XRP buyers, so I don't see them settling that part of the case. And the summary judgment opinion would remain on the books, which is the reason the SEC would likely appeal. So when I first read that, because he said, XRP holders and Ripple got to win on this the programmatic side, which is important to us. We're talking about sales where we're purchasing on secondary markets, not specifically from Ripple. And so he says that it happened, albeit in an insulting way for XRP buyers. So I read that and I was kind of scratching my head going, what was insulting about that? It was fantastic. I read the whole damn decision. I didn't see anything insulting in there. Attorney Morgan responded, and I think he was scratching his head too, because he wrote, I had dinner with 31 XRP holders tonight. Many are business owners. They don't feel insulted by the judgment. They would, however, probably feel slightly insulted by your remark. This judge is at least consistent with the rest of the world. Yeah, and spot on. So that's pretty much where I'm coming from as well. And Attorney Fagel responded and expanded upon what he meant. And this is what resulted in me rolling my eyes and deciding, okay, I got to jump in. He wrote, it was the judge, not I, who said retail XRP purchasers are unsophisticated. And so, folks, he's saying that the judge said that you and I, regular retail XRP purchasers, were unsophisticated. That's what former SEC attorney Fagel is asserting Judge Torres said. And then he wrote, and no, I'm sure they weren't insulted because they got the win. But if the court had used their purported unsophistication to justify finding a security sale, that might look different. And I was just sitting there like, I knew instantly the judge didn't say that because I read the decision. And after reading the decision, there were many instances I had to reference back to a ton of different parts of it. I knew that wasn't in there. So I pulled the damn thing up. And I shared a screen grab. And this is the first time I ever wrote to Attorney Fagel. I've just been reading his stuff. I've been covering him a lot on my channel because even though I don't find his arguments persuasive, generally speaking, although I agree with him on some things, I've gotten the gist that I think he believes what he's saying, which is interesting to me. So to have a counterpoint from somebody who is acting in good faith, that's fun and interesting, right? But here I was just like, whatever the intent, this is just wrong. And so I responded to him for the first time ever, rather than being a fly on the wall, because I knew I was right. And I said, the judge did not say XRP buyers are unsophisticated. She said programmatic buyers are less sophisticated than institutional purchasers, which is an important distinction. This is also true in legacy finance with purchases of equities, commodities, precious metals, etc. And here's the relevant portion. I made this screen grab myself. After hitting Control F, and searching for the word unsophisticated, it didn't pop up because it wasn't in there, just like I expected. So then I typed in sophisticated and found a portion which would be closer to what he was referencing, but it's not what he said it was. And it reads as follows. Lastly, the institutional buyers were sophisticated entities, including institutional investors and hedge funds. An examination of the entirety of the parties' understandings and expectations, including the full set of contracts, expectations, and understandings centered on the sales and distribution of XRP, supports the conclusion that a reasonable investor, situated in the position of the institutional buyers, would have been aware of Ripple's marketing campaign and public statements connecting XRP's price to its own efforts. There is no evidence that a reasonable programmatic buyer, who was generally less sophisticated as an investor, shared similar understandings and expectations and could parse through the multiple documents and statements that the SEC highlights, which include statements, sometimes inconsistent, across many social media platforms and news sites from a variety of Ripple speakers with different levels of authority over an extended 8-year period. Folks, are you guys offended by anything in there? Because I sure as hell am not. Why would I be offended? She's stating factual things. And so I expanded upon that concept in a separate tweet, and I wrote, Judge Torres unquestionably didn't insult XRP holders in any capacity whatsoever, acknowledging that people who engage in finance matters for a living are typically more sophisticated in the handling of such matters than those who don't is common sense. Why frame it like that? And so that was my question. All the judge was saying is you have these really sophisticated players here in the institutional level. They would be tracking all the stuff, what Ripple's saying, and being able to sufficiently parse it out. That's what they do for a living. And then she's saying, the typical retail speculator, well, of course, they're going to be taking a less sophisticated approach. It doesn't mean we're unsophisticated. It's just that that's not what we do for a living. That's the argument. But that's true not just of XRP purchasers. That's true of anyone that's buying, as I cited, commodities, equities, precious metals. People speculating in broad markets, they're not parsing through all that. It doesn't mean that all of them are unsophisticated, and that is not the assertion that Judge Torres is making. And so here you can see my perspective upon reading this. Looks like Attorney Fagel just wants to put the spin. Whatever he could do to make it look like there's a negative in there for us XRP holders. See, there's this dig against you. Oh, I'm not saying it. I'm Attorney Fagel. It's Judge Torres. She dissing you. No, that is not the reality of this. And I knew that he was just absolutely incorrect. And so that's why for the first time I just decided to jump in. And so Attorney Fagel did respond to me. So here's the timeline, by the way. So this was in the afternoon yesterday, 12:50 p.m. Central Standard Time. That's when I tweeted out my last tweet there. And then 4 minutes later, 12:54 p.m., Attorney Fagel responded to me. And he wrote, because I said, why frame it like that? And he wrote, because the court's logic resulted in an incongruous conclusion 180 degrees removed from the intent of the securities laws. Now, folks, that's clearly not what I was asking. I asked why he was framing the way they did, because what was the thrust of everything I just shared with you? Because he's dodging it. I said, why did you frame it like that? What am I referencing? Why did he frame it as though Judge Torres was insulting? That's all I was talking about. And then he didn't answer that, and he started talking about something different. I didn't care for that as much. It's like, come on, you know what you're doing, Attorney Fagel, right? Come on, you have to know. So that was 12:54 p.m. 2 minutes later, at 12:56 p.m., I had already responded. Because I saw that response pop up in real time. He got to me right away. And then inside of 2 minutes, I wrote, no, I'm asking why you'd frame the Torres decision as insulting when it clearly is not remotely such a thing. And crickets after that. And I think it's because clearly I was like, it's indefensible. Of course I was right. So I'm just highlighting it. It's just, I don't need the spin. I appreciate, the perspective from somebody who disagrees broadly with XRP holders, which is why I've been highlighting him. But the spin, come on. I get it. You think that the decision, broadly speaking, is wrong and bad and not good for investors. I just respectfully disagree. But this is such obvious spin. That's why he didn't respond to me, ultimately. And it's not like I was being rude or unreasonably confrontational. I'm just asking him to justify his position. Basically take a Socratic approach to this. Why are you arguing what you're arguing? And crickets. Okay. I guess I win the exchange. Is that how the internet works? You guys tell me. Here we have Coin Bureau. Coin Bureau. 811,000 followers on Twitter. Last I saw, they had something like 2.1 million YouTube subscribers. Maybe it's way more than that by now. I don't know. Nothing against the guy personally, but I don't know if he's just historically has had this bend against XRP or if he just has been uninformed and still putting videos out in a way that misleads his followers who trust him. I don't know. It's one or the other, or maybe a mix of the two. I don't know, man. So he tweeted out the following. The first thing's a small bit, but he wrote, "I guess this was always a possibility and now it has been confirmed." And what's he talking about? Well, he shared this headline. The SEC has signaled that it will appeal the recent rulings in its case against Ripple. So he says that it has been confirmed. The appeal is happening. That is not true. I made a video about this the other day. They indicated they're going to, but they haven't. It is not confirmed. I reported that. He's reporting something that isn't true to over 800,000 people. No. And so I responded to him and wrote, "They've indicated intent to appeal, but it's not confirmed." Attorney Bill Morgan responded to me with one word and wrote, "Correct." He then retweeted that and wrote the following and tagged me, Moon Lambo. I said, "Moon Lambo adding some calmness to the matter. The SEC argued Judge Torres' ruling was incorrect in a different court matter and that the SEC was reviewing the decision. It suited the SEC to support its position in that other matter by making that statement. The SEC could genuinely hold that view and state that position in matters in other courts for years without needing to have appealed the Torres decision. Some decisions that are not appealed eventually are considered bad law because they are not later followed by other judges. Just good luck for the parties that won those poorly decided cases. I am not saying the SEC won't appeal or the Torres decision is incorrect. Just saying the SEC can criticize it in other matters without appealing it and will certainly encourage other courts not to follow." Yeah, spot on. And Attorney Morgan has articulated that he does think what's most probable is that there will be an appeal. That's what most attorneys think. And then you have the opinion from Attorney Hogan where he thinks, no, that's not most likely because then they risk a binding decision from a higher court, which I find to be a compelling argument, but also I recognize the SEC is completely reckless, and they do things that aren't even in their own interest, actually. Like, bringing the lawsuit against Ripple in the first place, which obviously didn't go well for them. So, I don't pretend to know exactly what's going to happen here. But even so, what if there is an appeal? Well, let's talk a little bit about this, because there is I was tagged in a tweet by XRP community member Xerpsy. He asked if I had seen this, I guess, what is it, a newsletter? Yeah, a newsletter from Coin Bureau. And then he shared screen grabs of it, and then tagged me along with some others and just asking for thoughts on it. And I'm not going to read the whole thing just for the sake of time. If you want to pause, there's 4 screen grabs. I'm going to scroll through all of them. You can pause if you want to read all of them. I'm just going to highlight a portion of them, but I want to give you the option just in case you guys are interested. That's all 4 of them. But this right here is the one that I want to focus on because it has to do with this idea of appeal. And I just find so frequently, I just disagree with the analysis of this Coin Bureau guy. He says stuff confidently. People like the way that stuff's delivered. They like his channel, and congratulations to him for his success. But I'm just telling you, me personally, I so frequently on a variety of topics, not just Ripple and XRP related stuff, I so frequently think that what he's saying just doesn't make sense. Maybe that's just me. I'm just saying. And that's not an attack on him. I'm just articulating that I disagree with the intellectual, scatterings of this particular individual. I'll just put it like that. So anyway, part of this newsletter reads as follows. So how strong is this judgment really? So he's talking about the SEC v. Ripple case potential for appeal. He says, sadly, it's not as watertight as we would like. There are 2 reasons why. The first is that Judge Torres' decision on the matter is only a partial summary, i.e., she did not pass a ruling on all the legal issues present in the case. This means certain issues and questions in the lawsuit still need to go to trial to be decided. Okay, pause. It's true that, yes, certain issues are going to trial, but I don't see how it's reasonable at all to word things in such a way when you must know. If you don't, I don't know how you could not know. The most important thing when it comes to crypto markets, and certainly for XRP holders, that XRP itself is not a security. We got that. That's the one. That's not going to trial. So if Ripple loses on other counts, that's what we're talking about. Ripple or the executives, something doesn't go well for them. Okay. Well, sucks for them. I'm not saying I want them to get the shaft or anything. I'm not saying that. But you're presented in a way as like, oh gosh, should we be worried about XRP holders? No. I mean, not that we, and I'm also not saying, to be clear, I'm not going to the other extreme saying that, there's literally no chance. But I'm just saying the way he's framing it is as though there's a reasonable chance that things, including, well, everything under the sun that's being considered, could be flipped. And that's just flatly not the case here. So when it comes to XRP itself, Attorney Hogan already articulated why he doesn't even think the SEC can appeal it just from a technical perspective. But even if they did appeal it, I'll let Attorney Deaton speak in a second. I got something from him. But even if there's an appeal, he articulates why it's not going to go well for the SEC and it's not going to harm XRP holders with a virtual certainty. And so the way that stuff's being framed here, I just respectfully disagree with Guy from Coin Bureau. I just don't think that this type of framing is sufficiently in line with the reality of the situation. So he also wrote, also, the rulings in the summary judgment come from a district court, which means both parties can still file an appeal on them before a higher court. Remember that Ripple's programmatic sales only constitute a small percentage of its total XRP sales. Pause. The reason, that's not even true. Right now, since 2019, Ripple's programmatic sales constitute 0% of XRP sales. I guess he just doesn't know that. Ripple paused the programmatic sales in 2019 because they, presumably, I'm speculating here, thought that would have been more likely to have been illegal securities transactions, so they paused them. And it ends up that's not the case. Judge Torres found that's not the case, which is fantastic. That was a very pleasant surprise. But no, it doesn't constitute a small percentage of XRP sales. It constitutes 0%. Although after this ruling, don't be surprised that increases now that the ruling's been put down, come forth from Judge Torres. Resume if you want to resume the programmatic sales, whatever, go ahead, resume the programmatic sales. So, and then on the ODL side with XRP, I think that there's workarounds for that. I've talked about that in recent videos. I don't want to get into it here. But this is insufficient. So that's an outright inaccuracy, but that is now on top of insufficient. This is just what I've come to expect from Guy. It just is. This is why I'm critical. And then he says, as for the SEC, it has to contest the court's rulings on the programmatic sales because, if left uncontested, they could be taken as an admission of the SEC stance on the issue in future cases. So, be in no doubt, both the SEC and Ripple are preparing to file an appeal on Judge Torres' decision. Okay, look, maybe Ripple files an appeal, but if they do, if anything, it would probably be in response to the SEC filing some sort of appeal. But winners don't appeal. That's not what typically happens. Not that it can't happen. So him stating that if he's just stating it could happen, but he's insinuating here very strongly that they are going to. I don't think that makes sense. So let's break this down a little bit further. This comes from Attorney John Deaton. He doesn't think that an appeal would even be a setback. So in terms of the likelihood of this, we've kind of beat that to death. But would it even be a setback? Well, here's what Attorney Deaton had to say. An appeal is not even close to a setback. First, it will be 2 years from now before a decision is issued by the Second Circuit if it's appealed. The Torres decision is the law until then, at least in the Second Circuit. Second, even if the Second Circuit said Torres was wrong regarding her application of the third Howey factor, which I predict they won't, that doesn't mean the SEC wins on programmatic sales. It would be sales on exchanges. All that happens is that Torres then applies the other two factors and could likely still rule the same exact way, concluding the SEC didn't satisfy the common enterprise factor, which is a more difficult factor to meet, in my opinion, than the third factor. Don't let anyone underestimate how significant this win is for XRP and XRP holders and Ripple. Spot on. And then Attorney Deaton expanded further. He said, let me be more precise. I'm not suggesting that Judge Torres' decision is binding within the Southern District of New York. A fellow district judge could disagree with her, but I think a fellow judge in the Second Circuit is going to be hard-pressed to disagree with Judge Torres, especially considering she cited Judge Castell from Telegram. After reading the Coinbase transcript, we can see it's already playing out that way. Yeah, so so not only is it unlikely that Ripple's going to appeal unless the SEC appeals first, as far as whether or not the SEC is actually going to be, I'm skeptical. It looks like posturing. And then even if the SEC appeals, are they going to withdraw it at some point? Is it just to, kind of strong arm Ripple, and then before something starts moving forward, they're like, oh, no, oops, the doodles changed our mind. I mean, I could see that happening maybe. But to actually go forward with it and then risk binding precedent, I'm skeptical. I know I'm not the attorney, but I'm just saying unless they're going to do something that harms themselves, which we have seen from them. They shouldn't have brought the case against Ripple in the first place. That was dumb as hell. But unless it's something like that, I'm just not seeing it, man. And then there was this from Attorney Deaton. The only thing more pathetic than Bitcoin maxis guaranteeing XRP would be declared a security are those same maxis now claiming Judge Torres will be overturned. They have an open invitation to come on Crypto Law TV and discuss the Torres decision and any potential appeal. Warning, I'm bringing 76 years of case law and facts to the debate. Well, I have a suspicion, Attorney Deaton, you ain't gonna have any takers. I'm gonna guess. Maybe we'll be pleasantly surprised. But yeah, the Bitcoin maxis coming on. Good luck. You're gonna need it. Little room temperature cottage cheese eating sons of bitches, unsophisticated knuckle dragging, mouth breathing troglodytes with cashew sized brains. Those would be the Bitcoin maxi trolls wearing their Velcro shoes. So stylish, though. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.